Well, good morning, everyone, and welcome to this month's New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy. This is Sheehan Finney, and we're thrilled that you could be with us this morning. We just opened up the waiting room, and so we've got about 100 people that have already joined us. I think we've got at least another 100 to 150 that will be coming in. So I'll just start with a quick introduction as others are filling in. So the HR Exchange, this is our monthly meeting. Since COVID, we've gone virtual. We hope by the fall that we'll be back in person. But in the meantime, there are virtual meetings that we think have been very beneficial for our clients and guests. This month, we're going to be talking about wage and hour law and recent developments in the last year. But before we do that, a couple of quick announcements. One is that these sessions are available for credits. That information is available at the end of Brian's presentation. You will see that for HRCI credits, SHRM credits. But the other is, it's April, and that means next month we don't have one of our HR Exchange meetings because that's the high seasons for HR events, and the highest of the high season events is our annual employment law seminar, and that is our 33rd employment law seminar, 33rd annual employment law seminar. That's this year we've decided, because again it's virtual, to divide it up, and so we're doing it in 2 days, a Tuesday and a Thursday, the 25th and the 27th of May. That information is available on our website, sheehan.com, and again, the 25th and the 27th of May. We've divided up topics, everything from the American Rescue Plan to labor issues under the new administration, to wage and hour issues, to safety issues, and so on. Employees returning to work, continued accommodations, so on. All the things you've been dealing with in the last year, and then some, because we'll also do a preview of what could be next. That's on May 25th and 27th. It's a two-part series. They're virtual in the mornings of both of those days, just for a couple of hours each morning. So you'll be able to do it from your offices or your home office. The important thing to mention in that regard is you have to register for each event separately. I think currently I've been told that we have over 350 already registered for each of those days. There's plenty of room because, again, we're virtual. And then we're back on June 9th for our year in review, again, virtual. And so we look forward to having you join us. So before we went live, Brian and I and others were talking about this and said that wage and hour, that is certainly one of the 4 essential food groups for HR. And what's new? Well, there's a lot new, and Brian Bouchard is my partner and resident in our new Portsmouth office, and he has a great deal of experience dealing with both state and federal wage and hour issues as a counselor and a litigator, and he has spent a lot of time looking at these issues, especially in the last year as they've evolved, as many things have evolved with the COVID crisis. So please join Brian in this presentation, and know that he's got some interesting polls and scenarios to go through, and there certainly will be time for Q&A. So welcome, Brian, and let's go with the program.
Good morning, everybody. As Jim said, my name is Brian Bouchard. I'm a partner here at Sheehan Finney, and I'm looking forward to spending the next hour and change with you, going through some updates to wage and hour law. It's funny, Jim mentioned that before the program started, we had about 250 people coming here today. In my younger and more vulnerable days, I did a whole nuts to bolts class for the UNH professional development program on wage and hour. And quite unbelievably, I can't imagine that very few people signed up to take a 6-hour FLSA class with me, but I'm thrilled that we have so many people here today to learn about some of the updates to wage and hour, particularly FLSA wage and hour. Today's presentation is really going to be an update. Sometimes with this presentation, we do more of a back to basics review, but there's actually been a significant amount of wage and hour updates that occurred last year. And most of them actually occurred under the radar. Everyone was dealing with the FFCRA, PPP loans, COVID crises. And so, quite understandably, the pandemic was the focus. But while that was happening, the US DOL in the last year of the Trump administration was pumping out regulations, guidances, opinion letters that have quite fundamentally changed the way companies will approach certain topics under the FLSA. And we're going to talk about those today. So today's agenda, we're going to talk about the 80-20 rule and tip pooling and how that has changed recently with a final regulation. We're going to talk about perhaps my favorite FLSA topic, which is the fluctuating work week. We're going to talk about remote hour tracking, outside sales exemptions, referral bonuses, travel time and teleworking, which I think is going to become really important as companies go back to a more hybrid approach to the workplace, some New Hampshire updates, which are actually very few, and then the Biden administration forecasting what employers can expect the Walsh-run DOL to do and not do. Okay, so jumping into it, the 80-20 rule, these next couple slides apply mostly to those in the hospitality industry, but it's still important for people to know. So the 80-20 rule has been, in many ways, a thorn in the side of the hospitality industry for years at this point. And the USDOL has finally done away with it. But a little bit of background. Employers in the hospitality industry under the FLSA are allowed to take a tip credit. And what that means is they're allowed to pay the employees who receive a tipped wage a sub-minimum wage, with the idea that the tipped employee will make up the difference between the sub-minimum wage that they receive and the minimum wage prescribed by the FLSA. That's the idea. Of course, you have situations where tipped employees aren't always doing the job of a tipped employee. There are times when they're doing completely separate work, and there's times that they're doing work that is, perhaps related to the tipped employee job and work that they may do occasionally. So what the regulation said is that an employer could still take advantage of the tip credit that I was just talking about, even when an employee performs other work, so long as that other non-tipped work is related to the tip work and only occurs occasionally. If anyone knows, what the words related to and occasionally mean in that context, I am happy to cede the rest of this presentation over to you, because it was never defined, perhaps until recently. So what happened in the 80s is the USDOL promulgated this 80-20 rule, which effectively said that so long as an employee spends only 20% of his or her time doing non-tipped work, then the employer could still use the tipped credit even for that 20% time. After those guidances or regulations were published, the 80-20 rule kind of just became a leftover side dish, which is a really actually terrible pun. But it was forgotten about for a couple decades until there was a bevy of class actions about the 80-20 rule. The class actions were challenging, well, are these employees actually spending more than 20% of their time doing non-tipped but related work? And what's actually meant here under the regulations by related work? If a waiter is setting up a salad station, is that related work? Possibly. If a waiter is vacuuming the restaurant after the end of his or her shift, is that related work? Possibly not. So to resolve a lot of these issues and to resolve the bevy of class actions that have been going on for the last decade or so, the USDOL published new rules that have abolished the 80-20 rule in effect. And what those rules say is an employer may take a tip credit for any amount of time that the employee in a tipped occupation performs related non-tipped duties contemporaneous with or within a reasonable time before or after his tip duties. There's no more measuring 20% or 80% and trying to figure out exactly how much time an employee is allocating to a specific task. Perhaps most importantly, however, the USDOL has now defined what is considered related work. So if there's questions about it, an employer can go to the Occupational Information Network, and right there you'll see listed duties that are considered related. So for a waiter, that's bussing tables, that's cleaning dishes, that's making coffee, that's setting up the salad station, etc. And I think that's going to be very helpful for employers in the hospitality industry, going forward, because it's not always clear, or hasn't always been clear, what's been related work or was not related work. When I was in my 20s, I was working at the Bristol Homestead, and I was a waiter there, and it was clear when I was, setting up the salads that was related work. But during the daytime, when the owner had hired me to help paint the barn, that was obviously not related work. But it's never really that clear, and I think this is going to help employers going forward. Also, in the hospitality context, the USDOL promulgated regulations allowing tip pools now, which had never been allowed before between tipped employees and tipped employees and non-tipped employees. Traditionally, under the FLSA at least, a tip pool had to be between everyone who was receiving tipped wages or performing tipped work. So employers now, or those people in the industry, can now pool their tips with non-tipped workers, but only so long as the employer is not taking a tip credit, which we discussed in the prior slide. Going forward, the employer would have to pay the minimum wage to those employees in a tip pool. And it can be mandated. One thing to note, managers and supervisors still cannot retain tips received by workers under any circumstances, so be careful about that. In some instances, I know in restaurants that I've seen, the bartender may actually be a shift manager, and that raises questions as to whether the bartender who may receive tips from the wait staff for making the drinks throughout the night is actually a manager who can't receive tips or be part of a tip pool. So just be careful about that. And manager is supervisor is defined by the duties test for the executive exemption. So at least we now have a definition as to what manager or supervisor includes. So we're going to go to our first poll. And what's going to happen is I'm going to just read the question, and then I'm going to put up a poll, and everyone participating can say permissible or not permissible, and then we can talk about it. So Sandra manages the wait staff at Shenanigans Restaurant in New Hampshire, which I think is the restaurant that was in the movie Waiting. For months, line cooks have complained that they do not get paid enough, specifically because they do not receive customer tips, which are generally more lucrative for workers. The wait staff agree and feel guilty that the line cooks do not share in the spoils of their work. Trying to help, Sandra imposes a mandatory tip pooling arrangement and bumps the wait staff up to minimum wage. Is this permissible? Is this impermissible? What do folks think? And I'll open the poll right now. Give folks a few more minutes. No, anecdotally, it was funny while I was creating these polls. I almost felt guilty about creating them because this is supposed to be really a wage and hour update. And I felt kind of guilty about quizzing everybody, perhaps beforehand and afterhand, about stuff that they just learned. But it makes these presentations go by a little quicker, and it's good to have some interaction. All right, so let's go to the poll results here. 70% of you said that this is permissible, and 30% of you said that this is impermissible. So I'm going to end the polling, and you should be able to see the slide now. So this is actually impermissible. Despite what I just said about the FLSA and mandatory tip pooling arrangements now being permitted between tipped employees and non-tipped employees, state laws matter a lot. And New Hampshire's tip pooling laws are more restrictive than the FLSA regulations. In New Hampshire, tips are wages, and they are considered the property of the employee who earns them. And tip pools must be voluntary and free from any type of employer coercion. In the hypothetical that I proposed, Sandra was mandating that the wait staff go into a tip pooling arrangement with the line cooks, and that mandatory situation would make the tip pool impermissible in New Hampshire. So be sure to always consult the state laws when you're dealing with any type of wage and hour issue. In many respects, the FLSA, might set what the floor is in terms of what's required or not required, but states are permitted to go above and beyond, and that is what New Hampshire has done in this situation. So we're going to go to question 2, and then we're going to go and talk about something else. So ABC Corp has 30 non-exempt employees working at regular hours and receiving a salary intended to cover all hours worked. Because the salary is intended to cover all hours worked, ABC pays them an overtime premium of only 1/2 the regular rate of pay. ABC assumes that because the salary covers all hours worked, only the overtime premium of 1/2 the regular rate is owed. In other words, the 1 of the 1 1/2 times for overtime is covered by the salary. Is this payment structure permissible or impermissible? What do people think? And I will open the poll for that. Give it a few more seconds. Okay. Most of you have responded. I'm gonna end the poll now and share the results. So 83% of you said that this payment arrangement is impermissible, and 17% said that this is permissible. This is actually likely permissible. I know. This is payment structure is permissible, provided all requirements are met for the fluctuating work week, which is this sort of one part of the FLSA regulations that is easily my favorite FLSA regulation ever to exist. The fluctuating work week acts as a hybrid overtime model. And the reason I love it so much is that I've litigated a number of wage and hour cases, and even when employers engage in, at least in the First Circuit, employers have a misclassification in terms of who's exempt, who's not exempt. And it's truly just, they made a mistake. The fluctuating work week sometimes works as a way where the employer can kind of save its bacon here and minimize its exposure for the overtime that's owed on the back end. So the model recognizes that when an employee's salary covers all hours worked, the employee is entitled to an overtime premium of 1/2 the regular rate only, and not the 1 1/2 times the regular rate that you typically see with overtime. So for an example, an employee who earns $20 an hour would receive $10 for, it says hour, but what I'm calculating here is when you divide the hours worked by the salary, you come up with an hourly or regular rate. So an employee who's receiving $20 as a regular rate would be entitled only to $10 for each hour of overtime worked, and not $30 for each hour of overtime worked, although the regular rate will actually fluctuate as the hours change. Fair warning, however, the fluctuating work week is traditionally difficult to set up, and consequences for misapplication can be severe. If I hear through the grapevine that any of you have gone back to your employers and said, wow, I went to this great presentation today, I can save us 1/3 on our overtime, all we got to do is make everyone salaried and just pay them the overtime premium of 1/2 the regular rate instead of 1 1/2 times, I'm going to find you, okay? Do not do this alone. It is important that you consult with an attorney before even thinking about setting this up. But if you can set it up right, and it depends on the workplace, it can be a significant money saver for employers. So here's generally what you need. The employee must work hours that fluctuate from week to week. So if anyone's working a consistent 40 hours a week, not going to cut it. The employee must receive a fixed salary that does not vary with the number of hours worked from week to week. So what this can mean is there may be some weeks where an employee works 45 hours a week. There may be some weeks where an employee works 25 hours per week. No matter what, they're getting paid the same salary. And that's the risk that the employer takes on. The employee must earn more than the minimum wage, and the employee and the employer must have what's called a clear and mutual understanding that the fixed salary is intended to compensate the employee for all hours of worked, apart from overtime premiums. Now, historically, there have been some issues in having the fluctuating work week apply. And recently, the USDOL has promulgated regulations that have addressed those issues with the intent of giving employers a greater confidence in applying the fluctuating work week, because it can be a significant money saver for employers. So it's something that the Trump administration and its Department of Labor was keen to adjust. So here's the first change. Employers are permitted to pay employees bonuses, premium payments, commissions, hazard pay, and any additional pay without contaminating the fluctuating work week. What happened before, when employers tried to give premium payments for work on the weekends or hazard work or bonuses, is that the employee would say, well, now you're not paying me the same salary for all hours worked because there's these certain situations where I'm entitled to a premium. And because I'm entitled to a premium in those other situations, I'm not receiving the same pay for all hours worked anymore. Therefore, the fluctuating work week actually doesn't apply to me. And I'm owed an overtime rate of 1.5 times my regular rate of pay, as opposed to just the overtime premium of halftime, essentially. These regulations address that concern. In one of the few plaintiffs' cases that I had, this distinction as to when premium payments are paid and whether that affects whether an employee is paid for the same salary for all hours worked was actually a key fact in this case and won us the case. Change 2, the USDOL confirmed that hours do not need to fluctuate above and below 40 hours per week. In the First Circuit, which is encompasses where we are in New Hampshire and Massachusetts, that has always been the case, but now it is codified in a regulation from the USDOL, which is important. Many people had assumed that the hours have to fluctuate sort of above and below this 40-hour overtime threshold. That's not a case. You can have someone who's regularly working over 40 hours a week, but so long as the hours fluctuate from week to week, they would be eligible for the fluctuating work week. And finally, change 3, the USDOL clarified that a clear and mutual understanding does not require the employee to understand the mechanics of how the fluctuating work week actually works. And it can be complex when you are doing the calculations because the regular rate is actually changing from week to week as the employee's hours fluctuate from week to week. But the employee doesn't really have to understand how that works. The only thing the employee needs to understand is that their salary, together with the overtime and any bonuses, premium payments, and commissions that they may be entitled to, is intended to cover them for all hours worked. And it is, of course, best to have that clear and mutual understanding set forth in an agreement signed between the employee and the employer. So that is the fluctuating work week. If employers have questions about that, feel free to contact us. We're certainly happy to help people through it. Another word of caution, it's likely that the Biden administration is going to walk back some of the changes that were made, although we'll have to see. And there's some slides on that towards the end here. Okay, so question 3. Angel works for Clip Art LLC, a graphic artist. As a graphic artist. He normally works in an office from 9 to 5. Since the pandemic, he's been teleworking from Big Sky. Due to a high demand for clip art, I don't know why that would be the case, but who knows? Angel has been working longer hours, including an extra hour every night to finalize the day's sketches, which he then emails to his supervisor at the end of the day. As the distinctions between work and home dissolve, Angel has stopped logging all his hours, specifically the extra hour every night that he works finalizing sketches. Clipart has paid Angel only for the hours on his timesheet, even though he has worked more. And I'm going to open the poll. So the question is the way Clipart is paying Angel permissible or impermissible? And I will open the poll. I'll give it a few more minutes here. I should have prepared some jokes for these times in between. Maybe next time. All right, almost everyone has answered, so I'll end the poll and then I'll show the results. All right, so 28% of you said that this is permissible, and 72% of you said that this was impermissible. And we'll go back to the slides. This is probably impermissible, although I think an argument can be made. This scenario creates an arguable position. On the one hand, Angel's an hourly employee who has not fulfilled his responsibility of accurately reporting hours worked. That is the employee's responsibility. And it is not the employer's responsibility to guess, okay? On the other hand, Clipart may have constructive knowledge that Angel is working more hours than what his timesheets reflect because of the uptick in contract volume, okay? Here in this situation, Angel's hours haven't changed from, week to week, or the hours that he's logging haven't changed from week to week. And even though there's been a significant uptick in the amount of click art that he's required to create, you'd think that the employer will saying, well, hold on, we're getting crushed right now with contracts and with orders. How come Angel's hours are still the same every week? That's a little strange. And so in that situation, the employer may have constructive notice that something is going on, that Angel's actually working more hours than he is logging, which in that case puts the onus on the employer to maybe do a little bit more investigating and to pay Angel the hours that he's actually working, not the hours that he's recording. However, the USDOL has issued some guidance on this matter. And this is guidance, this isn't a regulation. What the USDOL is doing is it's collecting case law from across the country that is aligned with the way that the USDOL views this issue. But that is different than promulgating a regulation. Guidance is helpful to know how the USDOL is thinking about an issue, but courts are not bound to abide by that guidance. So you got to carry it with a grain of salt. As we just discussed, employers are obligated to track the hours of non-exempt employees. That has been true since the dawn of the FLSA. Employers are further obligated to compensate employees for all hours that they suffer or are permitted to work, including work that isn't requested by the employer and work that's not authorized by the employer, okay? So if you have someone who's going off the reservation and just performing a host of not authorized work, but you know about it, you still have to pay that employee the hours that they're working. The way to handle that situation is through coaching and maybe some constructive discipline, but the way to not handle it is to withhold wages from the employee. Never ever do that. There's ways around it, but you got to pay them for work that's even not authorized, because at that point they are performing a benefit for the employer. They are suffering and they are permitted to work. The transition to remote work over the last year and a half has frustrated record keeping for a lot of companies. And the USDOL has issued guidance last August stating that if an employer has actual or constructive knowledge of the work being performed, it is obligated to compensate the employee. And that's what we just talked about. Actual means that the employer has notice of the hours worked, either timesheets or what the employer is observing in an office setting. Constructive encompasses what an employer knew or should have known through the exercise of reasonable diligence. And here's the important part from the guidance. If an employee fails to report unscheduled hours worked through a reporting mechanism, the employer is not required to undergo impractical efforts to investigate further to uncover unreported hours of work and provide compensation for those hours. So generally speaking, no need to cross-reference phone records, computer login times, supervisor knowledge, etc., to pay the employee correctly, okay? But at the same time, employers cannot discourage employees from recording time correctly either. And this becomes a delicate conversation with dealing with employee inefficiencies and how you discipline that. So where does this leave us as employers here? On the one hand, you don't have to go through any impractical efforts to investigate the hours that are being worked. Certainly nothing to the extreme where you have to, go and cross-reference phone records and computer login times and consult with supervisors to figure out, what is actually being worked here. But you need more than just having a timesheet and that's it. Okay, if you just have a timesheet and you leave it to the employee's devices to accurately report what is being worked, that's not going to be sufficient either. So we're somewhere in between those two extremes, which is why I wrote the hypothetical the way I wrote it. I think in that situation, the clip art company would have some knowledge that something's going on with Angel given the extreme volume of work that has increased. Okay, so here's some practical guidance. Implement a web or app-based time recording system. That's particularly important if you have employees who are working remotely. Establish clear policies on time recording. Have an open door policy for complaints on pay or questions about pay. Conduct periodic audits. Again, you don't have to go and cross-reference everything every week, but if you do a quarterly audit or a semi-annual audit, that may help if this ever becomes an issue that's investigated by the USDOL. And train supervisors about avoiding after-hour emails and assignments and things that might cause an employee to work beyond the prescribed hours that they have. And I see there's some questions filtering in. We will get to those towards the end here. All right, question 4. Sterling Cooper is trying to save money. Instead of paying its inside sales employees the $684 a week required for the FLSA salary basis test, Sterling Cooper will pay all its inside sales employees $615.60 a week in base wages, 10% reduction, and the employees will receive the extra $68 a week through earned commissions. If an employee does not receive a sufficient sum in commissions, Sterling Cooper will pay the difference. The employees do not otherwise qualify as executive or administrative employees for the purposes of the FLSA exemption. I will open the poll and folks can let me know their thoughts. A couple seconds here. No cheating, no going to the regulations. All right, I will end the poll, share some results. 54% of you said this is permissible, and 46% of you said this is impermissible. This is sort of right down the middle, which is ideal. Let's go to the next slide. This is totally impermissible, very illegal. There is no exemption for inside sales employees, and I designed that question to be like that to begin with. It is very common to have people try to put their inside sales employees into an exemption or think that there is an exemption for inside sales employees. Right now, if you're inside sales employees, you have them as exempt from overtime. First, let me assure you that you are not alone. I've dealt with this issue for years. Second, if that's the case, contact me and we can talk about it, or contact your labor and employment attorney and you can talk about it. There may be some workarounds, including adopting the fluctuating work week. However, the USDOL has gradually been expanding the outside sales exemption, which is the only exemption that applies for sales employees, unless the sales employee otherwise falls into the executive, the learned professional, or the administrative exemption. All right, so let's talk about what the USDOL has said recently about the outside sales exemption. When this exemption was created years ago, it really only applied to people who spent, practically all of their time outside of an office setting, making sales. The vacuum salesperson who go door to door, the person from the Music Man who's in Gary, Indiana, selling musical instruments. That is an outside sales employee. But the Trump administration, USDOL, has been, gradually allowing outside sales employees to do more office-related work that is associated with their sales task. All right, so in an opinion letter from last summer, the USDOL recognized that employees who spend 80% of their time, here we go, back to almost an 80-20 rule, in company trucks going to festivals and events to peddle products and sign customers up for contracts are considered outside sales, even though they were heavily supervised and spent 20% of their time in the office planning events. Okay, and the supervision part is also critical, mainly because outside sales employees have generally been in a position where they're working on their own, they're doing what they ever need to do, and they're exercising discretion and judgment. The truck is not considered to be part of the employer's place of business, which I thought to be a little surprising. It's basically a box truck that looks like a food truck. It's owned by the employer. It certainly has a lot of artifacts in it that are owned by the employer. I thought that may be considered part of the employer's place of business. The USDOL has said no. So if you have outside sales employees, having them spend 20% of their time in the office planning events, doing things that are tangential or actually related to the upcoming sales events and strategies that they're going to be exercising, that's likely going to be permissible for the exemption now. In another opinion letter, the USDOL recognized that employees who travel to garden clubs and fairs and similar events to set up displays are considered outside sales employees, again, principally because they are making sales outside of the office and customers are buying from the employee at those events. The USDOL again evoked this sort of 80-20 type metric to measure time away from the office. And what the USDOL was looking for was that about 80% of the employee's time is spent making sales outside of the office. However, in that same opinion letter, the USDOL said that traveling to big box stores where these same displays are going to be set up didn't qualify for the exemption or may not qualify for the exemption because customers in that situation may be purchasing items from the third-party retailer, i.e. the box store, and not the salesperson. To qualify for the outside sales exemption, the person has to be actually the one making the sales. So what the USDOL said was we would need data showing in that situation that the employee is making the sales and not the third-party retailer. For those of you of outside sales employees, these are actually quite helpful opinion letters. Question 5. Production Co. LLC is desperate for skilled manufacturing workers. To assist its HR team, Production Co. implements a referral bonus program to pay $2,000 for every successful referral. Jake successfully recruits his friend Smitty to work at Production Co. Jake earned his referral bonus in a week that he worked 60 hours. He received his standard OT rate of $45 an hour. Was the way Jake was paid permissible or impermissible? And I will open the poll. This is going to be our last poll today, so people can kind of relax after this. No more quizzes. A few more seconds here. Okay, I'll end the polling and show you the results. All right, so 62% of people here said that this was a permissible way to pay Jake. and 38% said that it was impermissible. Slide. Dangerous. This is probably actually permissible for those keeping score here today. What I really want people thinking about is whether the referral bonus that Jake is getting is something that has to be calculated into his regular rate of pay and multiplied by 1.5 for overtime purposes, okay? The way this was set up, it's probably permissible to pay Jake his standard overtime rate, but you need to be really careful with this, okay? The way I set this up, Jake was earning about $30 an hour and his overtime rate was $45 an hour. However, if you factor in that $2,000 into the overtime rate, into his weekly pay, Jake's regular rate of pay goes through the roof, okay? It would come out to a situation where Jake's overtime rate in that week would have increased from $45 an hour to about $105 an hour, okay? That's a big difference. Not only is Jake getting the $2,000 referral bonus, but he's earning about $600 more in overtime for that week if the referral bonus had been something that would have been factored into his regular rate of pay, okay? Under the FLSA, the regular rate of pay includes all remuneration for employment paid to or on behalf of the employee, okay, for employment. But they're subject to some statutory exclusions, and referral bonuses are one. And the USDOL actually issued some guidance on this through an opinion letter last March. Such bonuses, referral bonuses, are not included as part of an employee's regular rate of pay if participation in recruitment is strictly voluntary, basically meaning that the recruitment process is not part of the employee's job, because if it is part of the employee's job, then the referral bonus is for employment, and then in that case, it would be considered part of the employee's regular rate of pay. What to look for is the employee engaged in HR, recruiting, hiring functions, anything like that. Is the employee's recruitment efforts do not involve a significant amount of time? To have the referral bonus not qualify or not be calculated within the regular rate of pay. This shouldn't be something that takes a lot of time for the employee. It should be something, quick. Here's Spitty, I think he'd be great. Interview him, that's it. Any recruitment activities should be limited to after hours solicitations among friends, relatives, neighbors, acquaintances, etc. Shouldn't be something that the employee is actively engaged in at work. However, in the facts of the USDOL opinion letter, which I encourage you all to read, they're right on the USDOL website, the employer actually paid the referral bonus in 2 installments. The first installment was paid when the employee joined. And under that situation, it was similar to Jake's here, where it wasn't for any employment-related activity, and therefore the first installment of the referral bonus did not need to be included as part of the employee's regular rate of pay calculation. However, the second installment became due a year later, which was really a way of getting people in the door for the employer, but saving the employer money as to when it had to pay out the referral bonus. It seemed like a good idea at the time. Except what the USDOL said is that second installment isn't so much a referral bonus, that's really a longevity bonus earned through continued employment at the company. And because it's earned, by staying employed, by doing your job for another year, well, that's payment for work performed. And once it becomes payment for work performed, then you're in a situation where the second installment of that referral bonus has to be included as part of the employee's regular rate of pay, okay? So I think what people need to think about here is, it's good to have, especially in these economic times when people are trying to get employees in the door, referral bonuses are a good way of doing that, but don't get cute in the way you set them up, because if you get cute in the way you set them up, you could be in a situation where the referral bonus isn't for non-work activity anymore. It's actually for work, which makes it included as part of the regular rate of pay, which can have some overtime consequences. All right. So travel time and teleworking. Coming out of the pandemic, it's more likely than not that a lot of employees are going to work part of the day at home and then maybe travel into the office or the job site. And there's going to be a mix of work from home and office work, particularly as vaccinations become more prevalent. But there is something to keep in mind, and that is the continuous workday doctrine under the Portal to Portal Act, which is encompassed into the FLSA. And what that doctrine says is that the period between commencement and completion on the same workday of an employee's principal activity or activities is considered compensable. Commuting time is generally never compensable, but certainly when an employee is traveling from work site to work site or has started the principal activities of their day and then is traveling from site to site, all that travel time in between is generally considered to be compensable time. So what is going to happen here when we have this hybrid approach and employees maybe who never would have worked remotely before are suddenly in a position where they can wake up at 5 o'clock in the morning, start some work at 5:30 and work for an hour, do some chores around the house, and then head right into the office, or maybe not even do some chores around the house, just do some work from home and then head into the office. Is that commuting time, maybe potentially up to an hour each way, is that suddenly going to become compensable because the employee now has a laptop and is able to start work at home and then is traveling to the office? The USDOL has helped clarify this. And what it said in an opinion letter is we conclude that when an employee A chooses to perform some work before traveling to the office, or B chooses to perform work at home after leaving the office, notice my emphasis on the word chooses, and in either case has sufficient time between her telework and office work periods to use effectively for her own purposes, the time she spends traveling between home and the office is not compensable. But the key there is chooses. This is going to be different if an employee is required to log on to get something, out to his or her supervisor in the morning, and then heads into the office for a 8 o'clock meeting. In that situation, the commute time, which normally wouldn't be compensable, may actually be compensable, okay? So that's something to consider. So be careful with hybrid teleoffice approaches. Probably the best approach here to avoid the situation, if you're going to do a hybrid approach, is having on a full day approaches where someone comes in for the day and then works from home the next day. Someone comes in for the day and then works from home the next day. And if you are going to have employees coming into the office for maybe the afternoon, but they're working in the morning, it'd be important to set some guidelines and parameters on what they're allowed to do or what's required of them at home before coming into the office, such that you don't find yourself having to pay for the commute time into the office. All right, so we're getting to the end here. New Hampshire updates. Hasn't been much. There's been an update to the Sunday day of rest requirements. If you're going to have employees work on a Sunday, you have to give them a day off, 24 hours off within 6 days after that. There's been some exceptions to that. There's a new one that employees in a recreation camp or a youth skill camp aren't required to comply with the Sunday day of rest requirement. And for public employees, there's some limitations on criminal record inquiries under RSA 275-37C. Each year, New Hampshire does publish its top 10, the New Hampshire DOL publishes its top 10 wage and hour violations. Here's the list of the ones from last year. And these are really simple stuff that sometimes just get forgotten about, but it's important to stay on top of these stuff. You don't want to find yourself on this list. These can be avoided quite easily, probably a week's worth of your time, and you can set up policies that will avoid most of these. So one is just failure to pay all wages due. We talked about that with the example I had from Clipart. If you have constructive knowledge that an employee is working additional hours, you need to pay the employee for that time. Record keeping continues to be a violation in New Hampshire, okay? Employers are required to maintain all pay records for 3 years. Know that, make sure you have a system in place to maintain those records. Don't find yourself getting fined for this. It's really easy. And let me tell you, from a person who does a good amount of wage and hour litigation, there is nothing worse than asking for the pay records and having someone tell me we don't have them. It makes my job incredibly difficult. And if you don't have time records, it makes the plaintiff's job extremely easy because in most situations, the plaintiff is able to say, yeah, I was working 55 hours a week. And unless the employer has records or evidence to rebut that testimony, the employee is going to get a presumption that what the employee thought he or she was working was actually what they were working, which isn't good. Youth employment, going to be careful there. The 2-hour minimum wage, minimum wage, excuse me, the 2-hour minimum, if you are calling an employee into the office and you send them home because you don't need them that day, you have to pay them a minimum of 2 hours. You have to provide notifications of changes in pay in writing. That includes changes also to benefits policies, vacation policies, and other fringe benefits. Documentation of employees, that has to do with completing your I-9s properly and employing employees who are legally allowed to work in the United States. Improper deductions from wages. That includes everything from not getting the employee's written permission to take out certain deductions for group benefits, to actually putting yourself in a situation where you may contaminate or spoil the exemption that would otherwise apply to an employee because you made deductions from the employee's pay because you didn't think they were working enough. And because of that, they fell below the hourly basis, or excuse me, the salary basis threshold and are no longer considered an exempt employee. Speaking of which, this is a good time to check your policies and make sure that you have a safe harbor provision to avoid that exact situation. Failure to secure workers' comp. This is an easy one. Any employer with 1 or more employees is required to have, some type of workers' comp insurance or some type of self-insurance. This is easy. Just get it. You don't want to have the fines of $100 per day per employee. Failure to have a written safety plan. Again, that's something easy you can take care of. And failure to pay the minimum wage. So let's talk about the Biden administration and what we can expect. There are joint employment unknowns that will continue to abound. Last January, the Trump administration issued new rules on joint employment. They issued a 4-factor test on whether the entity has the ability to hire or fire the employee, supervises and controls the employee's work schedule or conditions of employment to a substantial degree, determines the employee's rate and method of pay, and 4, maintains the employee's employment records. Think of a franchise arrangement in the situation. McDonald's often franchises its restaurants. It does not want to be considered a joint employee of the franchisee, even with indemnification agreements. So this type of joint employment definition is actually really helpful for companies like that, where you're franchising out your business, because there's very limited times when a McDonald's, for example, is going to be considered a joint employee under this test. Unfortunately for companies like McDonald's, a federal judge in New York struck down a key provision of the final rule. And this joint employment test, is no longer in effect. The Walsh DOL, for its part, has already entered the rulemaking process to reverse the narrowed rule that is described above in this slide. And we'll have to see what happens with that. But for right now, the joint employment test from the US DOL continues to be somewhat of a mystery. You can also expect from the Biden administration and the Walsh US DOL that you're going to have increased investigations, better funded investigations, an increased focus on workplace safety. The Walsh US DOL is likely to resurrect Obama-era policies like having to report workplace injuries instead of just having to record them. You're going to see rules and guidance on independent contractors, specifically for the gig economy, but like Uber, DoorDash, et cetera. But I would expect that whatever guidance or rules are promulgated, that's going to have a much broader effect than just the gig economy. You're going to see steps taken on pay equity. EEO-1 reporting is going to increase with all the information that employers are required to report each year. And we'll have to watch whether the Paycheck Fairness Act gets passed by Congress. There's going to be a focus on affirmative action compliance, and I would expect the Walsh administration, as part of the USDOL, to unwind Trump expansions of tip crediting, and fluctuating work week. So the fluctuating work week slide that I had talked about earlier, it may not last forever. I would expect that the Walsh administration is going to say that bonuses, commissions, and premium pay and the like can no longer be, added on to an employee's salary and still have the employee satisfy the fluctuating work week test. This is really a very good time at the beginning of the Biden administration and the Walsh USDOL to take some affirmative steps to get your wage and hour house in order. I would suggest that employers do an audit of their exempt statuses, do an audit of their pay records, and just do an audit of your independent contractors and make sure that everything is in compliance. This will also be a great time. Many employers are in a position right now where they're doing DEI training or sexual harassment training. Keep doing those. Those are very beneficial. But it may also be good to have a training on the FLSA basics, when someone is considered an administrative exempt employee, when someone is considered an executive employee. So that way that your supervisors know, that they can't just give assignments that don't require any discretion or judgment to someone who is an administrative exempt employee, because you might be in a situation where you blow the exemption. That type of training with the USDOL, one would look favorably on it and may help you avoid some FLSA related violations. I know Karen Whitley in our office has been preparing, such a presentation to give to management. If you're interested in that, please give us a shout and we can certainly set that up. But this is the time to do it as the Walsh USDOL gets underway, and as you'll see investigations starting to increase over the next 4 years. Okay, that was a lot of information packed into about 45 minutes. I see there are some questions. I will see if I can work my way through them. And other than that, I will let you out. Okay. So one of them is, please define the FLSA salary basis test. The salary basis test is part of what's considered for the white collar exemptions. There's a duties test and a salary basis test, meaning that the employee has to be paid a specific salary that is outlined in the regulations in order for them to qualify for the exemption. And I think it's on my slides earlier. It's $684 a week right now. I don't know if that number is precisely right, but I can certainly check the regulations at any point. So the salary basis test is just that the employee has to be paid a salary in order to qualify as an exempt employee. Another question is, should inside sales roles be classified as not exempt? Absolutely, yes. There is no exemption for inside sales. I see it multiple times a year. There is none. There may be situations where an inside sales employee is actually qualifying for the learned professional exemption, particularly when you're dealing with complicated engineered-based sales. That doesn't happen often. And there may be situations where you have someone who's the head of sales who qualifies for the executive exemption and sometimes for the administrative exemption. But generally, no. What you can do as an employee is, one, just the simplest way to, as an employer, is just pay them an hourly rate plus overtime, which is hard to track, I understand. You can adopt a fluctuating work week, talk to your counsel about that for sure. Or you can look at how much the sales employee is making. It's possible that they may qualify for a highly compensated employee exemption. Although even in that situation, they have to perform some of the duties of the executive, administrative, or learned professional test. Scrolling up here. Someone asked, what if the second installment is given in 6 months? Is that the same as a year? I think that question probably relates to the referral bonus opinion letter that we were talking about earlier. I think even 6 months is too long. Absolutely not, because at that point, you're still paying the employee for their longevity. And it creates an issue where because you're doing that, the referral bonus is going to have to be included in the employee's regular rate of pay, which could spike the overtime rate for that week if they're working overtime. If they're not working overtime, it's not an issue. So I wouldn't do 6 months at all. The longest I would push that is maybe a month, but I would just pay it out up front and avoid the issue altogether. Another question, in what industries do I typically see the fluctuating work week most applied? Sales industry, for sure. Individuals who are like HVAC techs who are on the road more often. I see that quite a bit. Another question, if an employee casually mentions that they are not reporting hours, the employer has a responsibility to request that they report all hours. Should they go back in time and retro pay all wages owed? So yeah, if an employee mentions that they're not reporting the hours and you go and look into the situation and it turns out that they're not, first thing is you need to have some coaching for the employee, maybe even the employee's manager in that situation, as to why he or she is not reporting all hours worked. And then, yeah, I would actually go back in time and look at the wages that weren't paid and pay them up front. Maybe particularly if you live in a jurisdiction like Massachusetts, where if you can pay those wages before a complaint is filed under the Wage Act, you can avoid the treble damages and attorney's fees that are associated with a Wage Act litigation. There's one question here from an anonymous attendee who's asking questions about the referral bonus and including it in the regular rate of pay, and asking is it included at the time that I think the question says, is it included at the time that the referral bonus is earned or at the time that it is paid? And that's a very good question, and I don't know the answer off the top of my head. I know it's in the regulations. But it's something that you'd certainly want to check into as to, you know, whether it's earned or paid. I think I think under the regulation, it is when the actual bonus is paid and not when it's earned as to the, actually, no, you know what? If whoever wrote that question, email me, I'll check into it. But I don't want to say anything wrong here, and it's either when it's earned or when it's paid, and I have to check the regulations to be sure, because right now I have two things going back and forth in my mind. And one last question here. Does the 2-hour minimum rule apply if an hourly remote employee clocks in and out to take care of a quick task outside of their normal work schedule? Under that situation, arguably, yes. If the employee is clocking in for the purpose of performing work for the employer, and the employer is, you know, requiring the employee to clock in to do that work. You know, the 2-hour minimum here is comes up in a situation where someone actually goes into office, you know, they're not needed that day. Let's say they're in the hospitality industry, it's going to be a slow day, they're sent home, they're entitled to 2 hours pay. If someone clocks in the morning, does a couple hours of work, clocks out, goes and takes care of some chores around the house, and then clocks in for, you know, the rest of the day to do work, that may not be a situation where the 2-hour minimum is going to apply. We are, I think, about at the end of our time here. If folks have additional questions, I'll try to answer them as best I can. If anyone is interested in doing any type of FLSA training, which again, I highly recommend, given the way that the Walsh USDOL is going to be approaching wage and hour issues, please contact us. We can set that up. My contact information is right here in this last slide. I'm in the new Portsmouth office. If I had thought ahead, I would do this on my phone and I could show everyone the new office. But we'll have everybody over here soon enough. And it's good to be with you this morning. And I don't know if Andrew or Liz, if we have any more announcements that need to be made.